I never thought I'd be the one to take down Karen Matthews, president of Whispering Pines, for 3 years. She'd ruled our neighborhood with an iron fist and a clipboard, measuring grass height to the quarter inch and sending violation notices if your mailbox was a shade darker than approved eggshell number 7. But even I couldn't have predicted how far she would go, or how spectacularly she would fall. It all started when my sister and her family moved in with me temporarily while their house was being renovated. My 11-year-old nephew, Ethan, has cerebral palsy and uses a wheelchair. He's the brightest, most determined kid you'll ever meet. The first day they arrived, we installed a small removable aluminum ramp over the 2 steps leading to my front door. Nothing permanent, nothing intrusive, just a practical solution so Ethan could come and go independently. The doorbell rang at 7:30 the next morning. There stood Karen, platinum blonde bob, perfectly styled despite the early hour, designer sunglasses perched on her head, clipboard clutched to her chest. "Good morning," she said with a tight smile that didn't reach her eyes. "I noticed you've made an unauthorized modification to your property." I blinked, still half asleep. "Excuse me?" "The ramp," she said, pointing with a French manicured finger. "It's not on the approved structures list for front entrances. Article 7, Section 12 of the HOA bylaws clearly states that all exterior modifications must be approved by the Architectural Review Committee. I'll need you to remove it immediately." I took a deep breath. "Karen, it's a temporary ramp for my nephew who uses a wheelchair. He's staying with me for a few weeks." She consulted her clipboard. "I don't see any approved accommodation requests in your file. You'll need to submit Form 3 for B with architectural drawings, material samples, and a physician's statement. The committee meets on the first Tuesday of next month." I couldn't believe what I was hearing. My nephew needs to be able to enter and exit my house now, not in a month. This is a reasonable accommodation under the Americans with Disabilities Act. Karen's eyes narrowed. The HOA predates ADA requirements, and our bylaws take precedence. You have 48 hours to remove the unauthorized structure or you'll be fined $50 per day. She spun on her heel and marched down my walkway, leaving me speechless. That day, I researched. Turns out Karen was dead wrong. The ADA absolutely applied to HOAs, regardless of when they were established. I printed out the legal documents and dropped them in her mailbox with a polite note explaining the ramp would stay until my nephew left, and that I'd be happy to discuss further if she had concerns. The next day, I came home from work to find a violation notice taped to my door. A $200 fine for nuisance correspondence in a non-approved mailbox receptacle. Apparently, placing documents in Karen's mailbox violated another bylaw. I had to laugh at the absurdity, but my amusement was short-lived. Saturday morning, while making breakfast, Ethan wheeled in crying, "Uncle James, someone took my ramp. I can't get outside to play with the other kids." I rushed to the front door. The ramp was gone. Not moved, gone. Through the window, neighborhood kids were playing street hockey. Ethan had been looking forward to watching them all week. My blood boiled. I knew exactly who was responsible. I carried Ethan down the steps so he could watch, then marched straight to Karen's house. Her pristine white colonial, perfectly manicured hedges a fortress. I rang the bell 3 times before she answered, in a tennis outfit, though I'd never once seen her play. "Where's the ramp?" I demanded. Karen crossed her arms. "I had it removed." Section 23 of the bylaws, regarding unauthorized structures and HOA remediation rights. "You were given notice. That ramp is my property. You stole it. Where is it?" I struggled to keep calm. She sighed dramatically. "The non-compliant item has been disposed of. If you continue with this hostile attitude, I'll have to report you for creating a disruptive environment, which carries a $500 fine." "Karen, that ramp cost over $800. More importantly, my disabled nephew now can't leave the house without being carried. That's not just mean, it's illegal. I'm simply enforcing the bylaws you agreed to when you moved here." She smirked. "Perhaps next time you'll follow proper channels." I stepped back, realizing I needed a new approach. "You know what? You're right. I should have followed proper channels, and now I will." I pulled out my phone. "Smile for the evidence photo." Her smug expression faltered. "What do you think you're doing?" "Documenting the person who committed theft and violated federal disability law. The police will appreciate it." I turned and walked away. She sputtered behind me. "You can't prove anything. The police don't care about HOA matters." But I wasn't going to local police, not yet. I called an ADA attorney. After explaining, he was practically salivating. "This is open and shut," he said. "Destruction of medical equipment, willful data violation, theft of property worth over $500. She's looking at serious consequences." Monday morning, 9 a.m. Two things happened. Karen received a certified letter from my attorney outlining the violations, and I filed a formal police report for theft and destruction of medical equipment. By noon, 3 families had come forward with their own stories of Karen's discrimination against disabled residents. That evening, Karen called an emergency HOA meeting. Nearly every homeowner attended, a stark contrast to the usual empty rooms. Karen stood at the podium, red-faced, clutching bylaws. "We have a resident trying to circumvent our procedures," she glared at me. "If we allow one unauthorized ramp, next thing you know, people will paint their houses purple and park commercial vehicles in driveways."